time is now in session.
Thank you. You may be seated. The time set for argument in Spring versus Bradford. It's our case number CACV150505. These proceedings are being audio and video recorded, so we would ask you to identify yourself and your client when you approach the podium for the first time. Each side will have 20 minutes for argument. Appellant will be required to reserve whatever time you'd like for rebuttal. We have read the briefs, considered the issues. We think we're familiar with the facts and issues. We've conferenced this matter already, and we look forward to your argument. Without counsel, you may proceed.
Good morning. If it pleases the court, Elliot Greisen on behalf of the plaintiff, Emma Spring. We believe that this case has been well briefed. I think the meat of the issues are already found in the brief. I thought I would perhaps emphasize what we view as the most important determining factors in this case. I'm going to try to reserve 5 minutes and do my best doing that. I do have time. I don't know. I did some research and tried to find out where the history of the exclusion rule, Rule 615. Now the federal rule is the same as the Arizona rule, I think as of 2012. The history of this rule, when you go into it, actually goes back to biblical times. It's in the book of Daniel, where he judged cases by separating witnesses so they couldn't hear each other. And it has continued throughout Judeo-Christian law, German law, English law, and has continued to this day for the same purpose. And that is, a party or a group of witnesses should not be able to tailor or shape their testimony to what has already been said in the courtroom, testified to. And in some ways, it's a bit one-sided in that the plaintiff has no opportunity, unless they do rebuttal, of course. The plaintiff has no opportunity to do what the defendants did in this case, because by the time the case is submitted on the plaintiff's side, it's too late to bring up new testimony unless you're going to get a chance at rebuttal.
Well, Mr. Greisen, let me ask you this. It seems like the mischief that is, the potential mischief that is anticipated by the rule or creating the need for this rule is obviated to a large extent by the modern practices of detailed pretrial disclosure and then of opinions as it relates to experts and then depositions. So by the time folks get to trial, there really is no surprise in that regard.
I would disagree with that, Judge Winthrop, and I would tell you the reason it does not is because the rule itself prohibits the witness from being in the courtroom unless a certain is showing made that they can allowed to attend. Every time I walked in and out of the judge's courtroom, I was told that this is the rule. Witnesses must remain outside the courtroom. The case law that's looked at exactly that issue, and we discussed it in the brief, but I think the case law that addresses that and in some way summarizes my opinion is Miller versus Universal Studios. And that is discussed at page 24 and 31. It's a Fifth Circuit case. And it's a funny case in that it was a copyright case out of a movie. And what happened during that case was similar to what you said. There was extensive discovery. Then, at the time of trial, secretly, as was done in this case, remember there was no application to the court, no showing that this needed to be done. In that case, there was the dailies were sent to the expert for the defendants throughout the plaintiff case. And the court in Miller reviewed that and said, despite the fact that there is discovery and despite the fact that, as you point out, you know pretty much what they're going to say, the trial itself is a sanctuary where the plaintiff's lawyer ought to have the opportunity to know that his exact questions and the exact answers are not heard and used by the defense to prepare themselves for their side of the case. It creates a sliding field where all of the advantage goes to the defendant to shape the testimony, not just to the general areas of discovery and depositions, but to the very essence of what you're talking about, what the jury actually hears.
Can you tell me, though, on this, tell us, Mr. Greisen, whether the defense expert's opinion changed at trial from pretrial opinion obtained by you in deposition as a result of learning what the plaintiff's expert testified during trial?
I think, if I understand your question, Judge Winthrop, that entire issue was addressed in Levy versus Parcell and discussed at 1933 through 35. And what the Levy court said was, in cases where it is impossible to show exactly what you just said, that presumption should be unprejudiced. And that is the holding of the Levy court. And it said exactly that. It said that in circumstances, the question you asked, in the circumstance where a rule is violated, and it's a fundamental rule that goes to the essence of the case.
Can you show something particularly unique to this case where there's something that came as a surprise that the expert testified to?
The uniqueness of this case is that in the same way as Levy was, it was a very hard-fought case that was turned on the credibility. It depended on which side you believed. Plaintiff had the plaintiff, her neurosurgeon, and a chiropractor.
But did the expert say something that came as a surprise?
A surprise in the sense, first of all,
I think he means it's a surprise as a result of the defendant's expert having that information about what was being testified to.
first of all, I think it's impossible to know the answer to that. That would be my first response to that. And that is what Levy says. It says that when it's impossible to show, I mean, you would ask me to get up their deposition, and in a deposition format, when I might ask completely different questions in order to broaden the scope of discovery and learn everything I could possibly do. In the trial format, I don't ask deposition type questions. So if your question is, Judge, can I show you the deposition testimony and then show you where it was changed during the trial testimony, my answer would be no, that's impossible to do. Because the questions that are asked of my expert are different than the questions that are asked by the defendants of my expert during his deposition and in disclosures. The discovery issue should not change in any way the fact that the trial court found that the rules were violated. They were violated in regard to the disclosure rules. They were violated in regard to both of the defense experts. And under Levy, the proper remedy is to presume prejudice under circumstances where they are violated.
Do you see any difference between a fact witness, the rule as it applies to fact witnesses and as it applies to expert witnesses? Seems to me it's much more significant when we're just talking about a fact witness than it is with an expert. Do you disagree with that?
I do. When you look at the rule, there is nothing in the language of the rule of Rule 615.
Well, I agree there's nothing in the rule.
There's nothing in the language of the rule that says that. And as a matter of fact, it says under C, the only one that the defense is arguing applies, a person whose presence the party shows to be essential to presenting the party's claim of defense. So what you would have to do if you wanted to send the dailies to your expert is you come to the court, which wasn't done. Come to the court and say, I want to send the dailies. I'd have a chance to object, and then the court would rule, and we'd have a record on why they think that the expert should have access to the dailies.
Mr. Greisen, let me ask you this question. It just popped into my head. If we extend your logic to the entire case, I mean, depositions that's a court proceeding. That is testimony. It can be read to a jury under certain circumstances. So we follow your logic. You'd be arguing then that it would be improper, absent court approval, to provide a copy of a deposition transcript, whether it be a fact witness or an expert witness, to your retained expert. Is that your position?
No, that is not my position at all.
Why does the rule not apply to that?
There is, because, Judge, the rule itself, by its very clear language, appears, it applies to the trial of the case. What happened on this particular case was I asked for the court to invoke the rule. The court invoked the rule as to trial. The court put posted notices on the door every time we went out. There was no objection by the defendants. The rule was included in the pretrial.
The rule is invoked, that triggers the provision.
Yes. Once the rule is invoked, then the rule provision is implied. And if for some reason the courts want to change the rule and apply it to depositions, that's a different story in my mind. I'm going by the clear language of the rule and what happened in this case. And I would also, if I can take it one step further, and refer you to a case cited at page 30 of our brief, and that's the United States versus Washington case. And that addresses this issue. And because now the Arizona rule is now identical to the federal rule, I would argue that this is persuasive. And what it focuses on, that a party's culpability in the violation of a sequestration order. The order is given by the court at the beginning of the trial. If the court wants, if the rules want to change and do it in the deposition, I think that's an argument for another day. But the violation of the sequester order and the party's culpability is a significant factor in determining whether the exclusion of the witness is the proper remedy for the rule. And then we've cited 6 or 8 federal cases that said the proper remedy for would be the exclusion of the witness if the attorney was involved in the culpability. And they distinguish here between if we're doing the trial and an expert witness accidentally wanders into the courtroom and here's some testimony. Well, then, of course, that's a different situation, which happened in this case. What happened in this case is the defendants decided to secretly, without telling me or the court, to have the court reporter provide them with daily transcripts so that they can send off several days in advance to their experts, discuss exact wording of exact questions, exact what they used on cross-examination, and turn it around to let the expert address it on direct. It's got such horrible I'm sorry, Judge.
Is there a prohibition on counsel simply asking their expert and essentially reading the testimony and asking, do you agree with this testimony?
I don't think there's a prohibition with discussing testimony, for example, over the phone or a briefing getting ready for the trial. What the rule states is that the expert witness can't be in the courtroom. And if you read that Universal Studio case...
How about if counsel just reads the expert's testimony or summarizes it while the expert's on the stand and asks them, do you agree with this or disagree?
I think
on that?
It's a totally... No, I don't believe so. I think it's a totally different thing to have the entire transcript transcribed and given to your expert as if he or she was in the courtroom. And that was the finding of Universal Studio. What Universal Studio said, the judge said, in my opinion, we keep the person out of the courtroom, but we give the other side, we give the defense in this case, a stronger tool to use against us than if they're sitting here. Because now they have hours and hours and days and weekends to go over the testimony without having any remedy to that type of behavior. We believe, as we said in the brief, this was an ambush of Dr. Bragman, using information that was not disclosed, set up, deliberate, intentional. We believe this was intentional, deliberate, a violation of the rules. We called it cheating in the brief. It was not an accidental wandering in of the expert.
What's your response to the trial court statement that had they asked, I would have allowed the expert to be in here.
First of all, we believe that was error. I would have argued that strenuously at the time. They would have to do a showing that the expert witness would be essential. And the word essential is defined in the federal cases as essential, not beneficial or helpful.
Are you aware of any cases where a court has excluded an expert from the courtroom under the rule?
I think in the federal cases that we've cited, yes, numerous times there have been battles about whether to exclude experts and family members and potential witnesses. That judges the purpose of the rule.
Well, family members and potential witnesses, I'm mainly focused. I'd like to hear specific cases dealing with experts that seem to me to be in a different category than a fact witness.
I don't believe the case law in the federal cases that we cite find them in a different category. And if they are, then there has to be a showing by whoever wants to have that expert witness. And remember, because the defense goes last, it's a one-sided benefit. It's a one-sided benefit. And the fact that we believe, at least on one occasion we found, the judge said, Judge Talamonte said he probably would have allowed the expert in. I would have opposed that because it's only one-sided. It's only the defendants who get a chance to listen to the plaintiff's testimony.
You can't recall a witness? Why wouldn't it also apply to your case?
I think, I guess in some cases you can recall a witness and do rebuttal, but I think the damage has already been done. I think it's one-sided because my whole case is in, and the two key experts for the defendants have an inherent advantage over me because they know exactly what was discussed in each of my expert witnesses. And in a lot of these cases, the federal cases that I cite, it's my recollection, and I don't want to take the time to take your time and point out, but there's always a dispute whether the witness should be excluded or not when it comes to experts. There's always a dispute, and typically the plaintiff wants them out, and the defendants will try to find some reason to keep them in. And I think the fact that the plaintiff goes first is the reason why the rule is unfair to apply as it was applied in this court. The behavior itself, we believe, was substantial, it was intentional, it went to a fundamental fairness issue in this case. It's been held that way in federal courts over and over again, that you don't get a leg up. And what happened in this case was they got a leg up, the case was close, it could have gone either way. The jury 6-2, they needed 6. It turned on credibility, and when the defendants broke the rules, they were allowed to attack the credibility of my plaintiff's witness on things that were never disclosed, never part of the pretrial. They even asked to amend the pretrial because they knew it wasn't part of the pretrial. And when it comes to the expert witness, they were given a big advantage. Yes, it's impossible to show, but Judge, that's exactly what Levy addresses and says if you can't be expected to show it, then you have to presume prejudice. Otherwise, the only thing you can do is encourage the cheating that went on. And this court, for the matter of first impression outlined in our case on 2 issues, can say, stop this. We're not going to allow this to happen. We're going to enforce the rule as it's written. And if you want to bring in your expert witness or you want to send them dailies, you show it to the court, and let's have a hearing to see if it's really essential. I'll reserve the balance.
Good morning. Mandy Carvis of Sanders and Parks, appearing on behalf of Tim Bradford, D.C. May it please the court, counsel, I've listened very intently to your comments this morning, and I want to get right to the meat of some of those issues because I think that I can specifically address some questions that you didn't get exact answers to. You seem to understand that there's a vast difference between lay witness testimony and expert testimony. If we look to the purpose behind Rule 615, the purpose is to preclude lay witnesses from changing or tailoring their testimony based upon the testimony of other witnesses. Say that we substitute expert witness within that analysis, even though I agree with some of the questions have been asked that I think experts are different than lay witnesses. Say that you change that. One of the things that you asked Mr. Greisen is, did any of the defense experts change their testimony based on the fact that they read these transcripts? Absolutely not. And I think we all know good and well, had they done so, any change in that testimony would have been highlighted and briefed and made very specific. Medical malpractice cases, as this court knows, are very unique in that they are very expert intensive on both sides. Expert testimony is required to prove all aspects of the case. On the plaintiff's side and the defense, while we don't have a burden to prove anything, experts are very critical in our case as well. That's why we believe that they are essential. Again,
Could I just
absolutely, Your
ask,
Honor.
sorry to completely free associate here, but assuming, and I do view there to be a difference between an expert and a lay witness, but lay witnesses are deposed prior to trial as well. Can't we make the same inquiry, say, why do we care about the rule if you can go through and look and see if the testimony changed in any way?
That's a fair question. I think oftentimes lay witnesses are deposed. Sometimes they're not. And I think it goes to the issue, too, of the nature of the witness, in particular in a medical malpractice case. The case law tells us that because we now mirror after the federal rules that you're supposed to look to federal case law to guide us on that issue. And the federal case law that both of us cited specifically addressed the issue, saying that it makes no sense to say that a lawyer cannot consult with their expert once the trial begins. And Mr. Greisen himself said he wouldn't be here arguing if all we had done was read the exact testimony to our experts. I don't understand how there's any difference if I could have literally sat down with my expert and said, Dr. So-and-so said this at trial. What would your responsive opinion to that be? Of course, by that time, not only had we done extensive disclosures of both of our experts who testified, Solomino versus Yonan had a chilling effect in medical malpractice cases in that we don't have to script testimony, but we have to get pretty close. Otherwise, there are allegations of mistrial for lack of disclosure. I assure you, had any such testimony changed, that's exactly what we would have had happen here. It did not. And the fact that someone is deposed, whether it be a lay witness or an expert witness, you can certainly look to that testimony and you could impeach a witness. That's one of the main purposes, other than discovering what someone is going to say. It's the ability to give you the ability to impeach them at the time of trial. Had one of our experts said something that was in any way different or substantially different in any way based on their disclosures or their deposition testimony, I assure you that Mr. Greisen would have impeached them with that testimony. Not only that, he was allowed to cross-examine our witnesses in front of the jury about the fact that they had seen or read the testimony from his experts. The other thing that I want to address that I think is critical is that Mr. Greisen implied that the defense is the only one who can have the benefit of this rule because we go second. I absolutely disagree with that, and this is why. There's nothing that would prevent Mr. Greisen, if he wanted to get transcripts of our opening statement, transcripts of our cross of his expert, and give them to his experts after they testify and say, help me cross their experts, because this is clearly where they're going to go. Just because he chose not to do that doesn't mean that it's unfair. Not to mention the fact, had my experts said something that was different, that they didn't say in deposition, again, he could have impeached them. He could have moved for a mistrial. He also could have said, Your Honor, I reserve the right to bring back my experts to offer rebuttal testimony to specifically address these new things that their experts said. That never occurred. It was never requested, and that's because the testimony was not changed in any way. I want to address, if I can, the Miller case that plaintiff's counsel referenced quite frequently. And that being, I want the court to keep in mind that it's a Fifth Circuit case from 1981. It has not been specifically adopted by the state of Arizona. It's a very different case. We're talking about a case involving copyright and literary issues. The Miller case also cites a case called Morvant versus Construction Aggregates Corp. 570 F2 626. In that case, which again is cited by Miller, it specifically says, in which the court stated it could perceive little, if any, reason for sequestering a witness who is to testify in an expert capacity only and not to the facts of the case. So there again, even the Miller court is citing a case that acknowledges that there's a vast difference between experts and lay witnesses. The Miller court goes on to say that it appears that the defendant's literary expert is probably not the type of expert intended to be exempt under this exception. So they specifically address the issue of, was this expert the type of expert that would fall under that essential to a party's case? In a medical malpractice case on both sides of the issue, it's very clear that experts are essential to the case. Experts do assist us in the manner in which we are going to handle that case on a going forward basis. In the discovery process, one of the first things that we do is send our experts plaintiff's preliminary expert opinion affidavit and ask them to offer responsive opinions, which we then disclose. Witnesses are then deposed. We send the deposition transcripts to our experts for the same reason, to give us responsive opinions, help us decide how we're going to address these issues. And the other important thing that I want to address that I think is critical here is plaintiff's is not correct that prejudice can be presumed in this situation. The case law is very clear that you cannot presume prejudice. In fact, the trial court's minute entry order on the denial of the motion for new trial specifically pointed out that the instructions and the opportunity to cross-examine prevented actual prejudice. Plaintiff can't show prejudice here because there was no prejudice.
So there's no remedy for a violation of the rule?
I don't believe that it was a violation of the rule, Your Honor, but the remedy that was given and enforced by the trial court, I believe, was appropriate to address it under the circumstance, that being the instructions. That instruction, the instruction that was given, not one but two, one was given for each of our witnesses, and those instructions were taken directly from federal case law, Hill versus Porter Memorial Hospital and LaPena versus Upjohn, that are both cited in our brief. And in both of those instances, they said that the jury could be advised that it could consider a witness's review of trial testimony in evaluating that witness testimony, and that an instruction was sufficient to correct the risk of unfairness. Again, we don't believe that what we did was a violation of the rule, but in the event that the court deems that it was a violation, we believe that it was corrected by the instructions that were given to the jury, in addition to the fact that Mr. Greisen had the opportunity to cross-examine our witnesses regarding their review of that testimony.
Are you advocating for a blanket rule that it's never a violation of the rule when it's an expert?
What I would advocate for, Your Honor, is some clarity for both sides of things. I think that this has been an issue that there's great debate behind the scenes on for a long time. We would contend that the subsection 3 of Rule 615, a party essential, does apply to experts, and we would ask that this court specifically address that issue as to whether or not it is.
But if someone just designates someone as an expert, it seems like the better rule would require some court involvement to keep someone from just designating someone who may be, there may be some testimony that may be somehow a combination fact, expert, witness. How would we possibly come up with a rule that says any time someone designates an expert, the rule doesn't apply?
And I think that's fair, Your Honor, and some of the case law contemplates, in fact, Miller says that this isn't the type of expert that is contemplated as being essential. We deem an expert in this type of case, in a medical malpractice case, as being essential on a going forward basis to make sure that there is clarity on these issues. If there is a perceived violation in sharing this testimony with experts, what we would ask for on a going forward basis, again, would be clarification that if you deem your expert to, quote, be an essential party, that you raise that with the trial court judge prior to going forward. We did not do that in this case because we had never done that. Mr. Salmons has been practicing for a lot longer than I have, and he has done that for 30 years. And any time that he had been in trial and I had been in trial, and we cited the McGuire case, which is listed in the Arizona Civil Rules Handbook, that specifically says that you can permit one side's expert witness to hear the testimony of an opposing side's expert in order to be in a position to suggest areas for cross, that had been the end of the issue. What I can tell you on a going forward basis since this trial, the way that I have personally chose to address it, is putting a statement in my joint pretrial statement that I contend that Rule 615 does not apply to my expert witnesses and that they fall into that exclusion, and let the trial judge and opposing counsel know that ahead of time. I don't believe the language of the rule or the case law at the time of our trial required us to do that as a practice pointer to avoid this issue in the future, unless and until we have some instruction from this court as to how to handle it. That's how I've chose to handle it. So I think what could happen on a going forward basis, Your Honor, is to say that if someone wants to contend that an expert is, quote, an essential party and someone who is not subject to the rule of exclusion, that that's something that should be addressed with the trial court prior to going forward. However, we had no such case law to instruct us at the time that we were in our trial. So if that's the ruling on a going forward basis, I think that would be very instructive. However, obviously that's not something that we could, a standard that we could be held to, because it was not in place at the time. I think I want to, if I can, just briefly again address this issue of prejudice, an actual prejudice versus a perceived prejudice. Again, there's a reason that they can't show prejudice. That's because it didn't occur. The trial court specifically determined that they were not prejudiced by the alleged violation. They filed some supplemental briefing on the issue of presumed prejudice, and that case law specifically says, and it was American Power Products versus CSK Auto, and that was in their supplemental authority. It's not applicable to this situation. It deals with presumed prejudice for improper ex parte communication with a jury. That's clearly not the issue that we are here to address today. We don't believe that there was any prejudice at all. If there was, they have to be able to establish that. This is not the type of scenario where prejudice should be presumed. We believe that the trial court appropriately addressed these issues and determined what the appropriate remedy would be for the alleged violation. They gave not one but two instructions, and the jury rendered a defense verdict. There was nothing about the provision of these transcripts that changed our expert's testimony. Again, Mr. Greisen told you that there would have been nothing that prevented me from saying, Dr. Iverson, during trial, Dr. Bragman said the following. Do you agree with that? If not, how would we address that? This rule was not intended to prohibit counsel from corresponding and speaking with their experts during the case. We believe that the trial court's decision about how to handle the alleged violation was appropriate. The trial court specifically ruled that there was no actual prejudice. And as this court knows, you're supposed to consider the evidence in the light most favorable to upholding the jury's verdict. The trial judge was there. He heard the testimony. He had the opportunity to hear and see the witnesses. If there had been any change in the testimony, you wouldn't have to be asking where it was, because it would have been highlighted for you. We contend that this issue was handled appropriately. We do agree that on a going forward basis that this is an issue that would be very instructive for Arizona attorneys in medical malpractice cases, but in all cases in which they use experts.
Could I ask if, assuming that were the rule, would the plaintiff then be entitled to the jury instruction advising the jury that the expert has had the benefit of reading or what they call it, the benefit, the expert has reviewed the testimony from the opposing expert? Would you still offer that jury instruction?
If that were the rule, I'm confused as to your question, Your Honor.
Well, if the jury instruction was a remedy to the violation of the rule, if you had asked ahead of time and the court had said, yes, I'm going to deem this witness essential to the defense, Does the jury get the instruction in that situation?
I now understand your question, Your Honor. Thank you for rephrasing it. I don't think the instruction would be necessary in that regard, because I think what would occur is exactly what occurred in this case, that being that Mr. Greisen would have said, prior to you taking the stand here today, you had the opportunity to review a transcript of my expert witness's trial testimony. Isn't that correct? So I think that the jury certainly heard about it and knew about it prior to receiving the two instructions, but I think if it were addressed on a pretrial basis, that the instruction would not be necessary because it would be clear, and I think it would be a subject of cross-examination of both experts potentially. Unless the court has any other questions, I believe that's all I have, but I do appreciate your time and attention.
Let me see if I can just address some specific points that were brought up. First of all, I don't think the court has the judicial power to say we aren't going to follow Rule 615 as it's written. I don't think the trial court has that power. If Rule 615 does not apply to experts, then that's a job for our Supreme Court. Change the rule. Tell us it doesn't apply to experts. As it is written, it applies to experts. As it was changed to follow the federal rule. The federal cases are all persuasive that it applies to experts, not just lay witnesses. The McGuire case is not good law, and we talked about that at length in the brief. And the defendants at the bottom of page 4 and the top of page 5 played a little trick where they put point, as if they didn't finish the cite from Udall. And what the cite actually says, if you go back and look at it, is that preparing the witness for cross-examination is what they were discussing. If an expert has to be in for direct testimony by my expert to prepare the defendants to cross-examine, that's a different issue. By this time, the experts were long gone. My experts were back in Atlanta. And my experts were, Dr. Liebman was back at his office practice. I mean, the rule, once it applies, it has to apply to everyone the same. I don't think this court can hold that Rule 615 doesn't apply to experts. I don't think that's the power of this court either, and I don't think it'd be very discretionary to do so. I think that's a job for a Supreme Court. Levy, presume, in Arizona, the Arizona law is that prejudice and circumstances like this is presumed in criminal cases. That is the law. We discussed it for 3 or 4 pages in our brief. Isn't it true that the civil person, in my case, an average citizen, ought to be entitled to the same protection as the criminal is in a criminal case?
Even if there's a presumption, if the trial court tells us, I would have granted your request if you had asked ahead of time, doesn't that tell us that the error, if an error in not requesting ahead of time is harmless?
I think, Your Honor, that we disagree with that as discussed in our brief, and the trial court did not know what to do with this because he was not familiar with this happening. He had not had a defense attorney secretly send off trial briefs. And he gave the instructions that he thought was appropriate. However, Levy, and you read the whole, we're relying on Levy strongly here. You follow Levy, we believe we prevail and get a new trial. Levy said specifically, in cases like this, where you presume prejudice, stock instructions are not sufficient to change the damage that has been done. And that's what happened here. The jury had no idea what to do with those instructions. It was up for the trial court and now for the Court of Appeals to enforce Rule 615 as it's written and as it's interpreted. And that's what we're asking you to do.
Thank you.
Thank you.
Thank you both for your argument. We will take this matter under advisement and issue a decision in due course. And we are adjourned. Thank you.